Sir, we are live. Om Prakash ji, if you could please turn on your video.
Yeah.
Sir, we are live.
So, good morning. Ayush would like to initiate introducing the about the NRS and all these things.
Namaskar. Today we have Dr. Ashish Kumar ji with us. So Dr. Ashish Kumar ji is a senior assistant professor at Law Center 2, Faculty of Delhi, University of Delhi, India since 2013 with over 12 years of teaching and research experience. He primarily teaches international law and constitutional law. So today we request Dr. Ashish Kumar ji to enlighten us and have a good discussion. Welcome, sir.
So, I would like to thank NRS for inviting me for moderate this session. And now I would like to invite Dr. Ashish to share his thoughts. Dr. Ashish.
Thank you, sir, for extending me this opportunity today. And thank you, Ayush, and also the organization called National Reconstruction Society. So Ayush has been in touch with me for the couple of months, and since I was quite busy with the admission-related work and other committee-related works at the university, so I could not make it earlier. But I was inclined to share my thoughts on some emerging arena, a very controversial domain for which there is indeed not yet fully explored academic material available. And but I would like to restrict my discussion on the issue of lack of political shame in today's society, instead of expanding it to so many other domains. Will rather try to restrict my discussion on the political shame. um, so I would like to share my PDF today here. Is the PDF visible?
Yes, sir, it is visible. Yes, sir, it is visible, sir.
Okay, thank you. So the title I have chosen for discussion today is Erosion of Public Shame and the Threats to Ethical and Legal Order in Contemporary Society. So before I dwell into the topic, let me just share a few initial thoughts as to why I have picked it up. It is in the background of the very, very damning revelations through these Epstein files. You may have read about it, Epstein files in the United States, which has, and I read it, not all the files, but largely speaking, the ones which have very damning impact on the political order in the USA. Those revelations I have read. And even before that, I have been very consistently thinking about this very fast erosion of this public shame, which did have a lot of impact on the political class a decade ago, or maybe 2 decades ago. in several countries, including India, but now we see that it does not make any impact. So the purpose of this discussion is to enlighten uh, the audience, and also to throw into the public domain a very critical issue which we very seldom talk about. It is happening in real time and it has impact, but we do not try to discuss it, or we just let it go because of so many reasons which we will be discussing. So therefore, the first starting line of this discussion is about the 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 academic role or the critical role of shame in as a social regulator in our society, but also having a lot of connotations of it in our legal system, in the legal jurisprudence, which goes by some other names like guilt, has slight subtle distinction with guilt. We'll be discussing about it, but it has connotations, not exactly um, that it appears by this name shame in our legal jurisprudence, but has other names to it. For example, guilt could be one of them, remorse could be another term, but by and large, it has had a very powerful role of a social regulator in any given society. So I begin by this the quote taken from Kathy O'Neill. Uh, she has authored this book, The Shame Machine: Who Profits in the New Age of Humiliation, published by Penguin 2022. And she says, it is a very powerful and sometimes useful tool when we publicly shame corrupt politicians, abusive celebrities, or predatory corporations. We reinforce values of we reinforce values of fairness. Psychologists define the term in its own way. They call it a very powerful self-conscious emotion, which has historically played a very significant role in shaping human behavior and maintaining social order. It emerges from the awareness of transgressing social, moral, or legal norms, compelling individuals to align their actions with communal expectations. So legal systems all across the world have historically relied on shame to complement formal sanctions. It is done through various means, for example, through a strategy called publicly naming and shaming individual, which a kind of that we also see in our tax jurisprudence, where uh, the the tax evaders are formally named and also allowed to be shamed by the public. But the instances of publicly naming and shaming individuals for having transgressed laws or social norms are far and few between. Very rarely we see that emerging in the public domain. But under international law, we have several instruments to to ensure that individuals accused of violating international laws, in particular human rights laws, are publicly named and thereby allowed to be shamed. For example, under the UN Charter, UN international human rights instruments like CEDAW, CEDAW, ICCPR, CAT, that is the Convention Against Torture, 1984. ICCPR is the leading international human rights instrument, and some others, in particular in the European Union, ECHR also. They uh, allow for transgressors to be named publicly, and it has a lot of reputational costs. And if the entities are corporates, I mean, if the individual is a corporate honcho who is often accused of transgressing several norms, several laws, taxation in particular, they have a lot of reputational costs. So it has a deterrent role in deterring the activities. And so in company matters, publicly naming and shaming has had a good role to play and has had some good impacts when contrasted with the political class. So moving further, we can think about the ideas surrounding public shame. It can be traced to several legal thinkers. Uh, Aristotle, in particular, in his Nicomachean Ethics, has said that shame is critical in political communities as it encourages citizens to adhere to laws and communal norms. A very leading Australian criminologist, forensic science expert, John Braithwaite, you may have heard of his name, in his seminal work, Crime, Shame, and Reintegration, had propounded a, a theory called uh, it's called reintegration theory, in which he has described that shame has a very reintegrative implications. That is to say, the individual who is shamed can feel really internally compelled to be reintegrative, and so as to ensure that he reintegrates into the society by by atoning for the moral transgressions or violations of the ethical norms or legal norms, by atoning for such transgressions. So he contrasts this reintegrative aspect of shaming from the other detrimental impact which it could have, which which Martha Norsenbaum has said that it can also have a lot of negative implications, and therefore she's not in favor of Martha Norsenbaum. You may have heard of her uh, works. So she is not too much inclined, but she does recognize also about its role in ensuring that individuals mend for their crimes, for their violations. So John Braithwaite, in his seminal work, describes public shame as a reintegrative tool, condemning acts while respecting individuals, and it can foster ethical behavior in communities. So far as the legal thinkers are concerned, H.L.A. Hart stands out very clearly in his Concept of Law 1961. He views public shame as a social sanction which can reinforce legal norms, and this is needed because it can complement the formal penalties by signaling moral disapproval, and that is very essential for law's legitimacy. In Hiding from Humanity, 2004 work of Martha Nossenbaum, she defines public shame as an emotion that can foster empathy but risks dehumanization if overly punitive. So she is a bit critical, but essentially also inclined towards letting public shame exist in the jurisprudence. In our own country, there are leading thinkers. Mahatma Gandhi has also explicitly said that public shame does have a role to play. It is a non-violent tool, and this is very remarkable because, as we all know, that public shame is only to name an offender in public record, and which allows the offender to reflect very deeply. It can, or it may or may not be. It may not be because of the current climate where public shame is totally reduced and nobody feels remorse or uh, list to speak about being publicly shamed. So Gandhi said he viewed public shame as a non-violent tool for social reform, emphasizing satyagraha to expose injustices and evoke moral accountability. His public fast shamed oppressive systems, fostering encouraging ethical discourse. B.R. Ambedkar also stands tall in this connection, and he viewed public shame as a tool to challenge caste oppression, arguing it could expose and deter discriminatory practices, fostering social justice. And this he said in his seminal work in Annihilation of Caste. And he emphasized shaming caste-based wrongs to uphold equality and ethical order. Now, coming back to what I was talking about earlier, shame is distinguished from guilt. There is a subtle distinction, but guilt we all know, which is a typical term used in the criminal jurisprudence. And shame is, in that sense, is more informally used. But shame and guilt are emotional responses, which we all know, to wrongdoing, but there is a slight subtle distinction. Guilt is internal, and it is tied to a specific action, like when a convicted thief regrets stealing data and thereafter apologizing to make amends. So he said a typical way of acknowledging his wrong is that the thief saying, "I did wrong." So focusing more on the act, and therefore he is begging for atonement, or he is seeking restitution. Whereas the shame targets the self, like a politician feeling inherently wronged after, inherently flawed after a corruption scandal. And if the shame has worked, he is likely to say, "I was wrong. I am wrong." It is more deeper, often tied to internal psychological mechanisms. It can be tied to self-loathing, which may not appear to be a good word, but this is more deep. It emanates out of the fear of social rejection, driven by internal reflections, or the fact that the public has come to know about the gravity of the wrong or the crime which he has been accused of and convicted for. So guilt seeks atonement for the wrongful act. Shame questions one's worth. So it is more deep. So that's why it has a lot of utilities, especially when the shame has worked on an individual accused of committing crime with full in public knowledge. So he is likely to mend ways through atonement. Unlike the focus of guilt, which is only on this specific action. So we may think about distinction through this exemplification. So not all guilty feelings are shameful, and not all shame involves guilt. And a typical example is given, like when a student is found cheating in an examination and he regrets it. He wants to apologize. So his focus is more on being pardoned for his actions. But if he is shamed, which is a strategy or a tool in the hands of the university administration, he is likely to be also equally shamed for what he did. So there is a subtle distinction which we want to bring about in order to have this knowledge of the distinction between these two similar sounding terms. But overall, beyond these distinctions, the idea is that public shame is not formalized. This has played a role as a strategy in several legal instruments. For example, I cited the example of international human rights instruments, ICCPR, CAT, CEDAW, all these international human rights instruments. They do have this strategy of naming and shaming errants, or the ones who have flouted the legal norms, so that it can have repercussions and can have deterring effect. Coming back to its constitutional relevance, So the constitutional relevance or its legal jurisprudential relevance can be sourced to the H.L.A. Hart's magnum opus, The Concept of Law, where he says uh, public shame amounts to social disapproval, which can help enforce laws by encouraging people to follow rules. And those who are from the law background, know the internal aspects of law. There are external aspects of law and also internal aspects, and we are more focused into the external aspects. So somebody has been punished, that's it, he deserved it. But whether or not the the punished person has indeed atoned or has indeed made amends to his behavior, that remains a question. So, so in India, also we have some examples of using, not formally but informally, through the social media platforms, uh, which manifested in the form of this Me Too movement, which exposed powerful abusers uh, and had a good impact to some extent, to reasonable extent. So RST uh, is almost integrated in several um, laws, legislations, which says, especially in the restorative justice programs of leading jurisdictions like Australia. John Brathwaite is from Australia, so he talked about, as I said mentioned earlier, he talked about this reintegrating shaming theory. That's what is called RST. So that has found applications in restorative justice programs of some jurisdictions, for example, Australia. Now, in terms of legal implications of this RST or public shaming strategy, uh, legal positivism cannot address this problem of diminished or eroded public shame in our society today. Legal positivism, as we all know, is separates law from morals, and it can only punish what is very obviously a violation of legal norms. Uh, so a given legal act which is reprehensible, a given violation which is morally wrong will not be punished because it's not a legal violation. So therefore, we can situate, or we can take umbrage in or shelter in natural law theories, which can provide answers to the way this problem of diminished public shame could be tackled. So natural law philosophers, or this school of law, is more suited to explore the problem of declining public shame. This is just for our thoughts to make future deliberations on this problem. So this I have already talked about, public naming and shaming in international law. We have UN Charter, which creates several UN bodies, and their resolution system does adopt this publicly naming and shaming practice or a strategy to deter violations, or to ensure that violations are not repeated. ICCPR has a very explicit provisioning for this. CAT, UDHR, and sometimes um, non-governmental international organizations like Amnesty International or Transparency International, they do also come up with this sort of a strategy. So obviously, till because this area is totally unexplored, um, and it requires more exploration in the wake of this social media proliferation, where there is no cost uh, for for saying for saying anything and everything under the sun. There is no cost. There is no reputational cost. Anonymity, social media anonymities protects those errant individuals who misuse these platforms. So it has had limited impact under the international human rights regime, especially when the entities are corporates. Uh, it can have some good impact because the public narratives can start getting built up against the violator entity or even a state, which can have spillover effects on other areas, for example, trade, investment, economy of the violated state. So far as this international aspect is concerned, there is this latest work by a faculty professor of political science at University of Chicago, Rochelle Terman, and she has come up with this latest work of 2023, published by Princeton University, titled Geopolitics of Shaming: When Human Rights Pressure Works and When It Backfires. Now I come to the most interesting aspect of our discussion. I began by saying that the current discussion is inspired by the latest damning revelations under this Epstein files. Can I ask you, have any one of you heard of this Epstein file, which is making news right now? Ayush, have you heard of it? Epstein files?
A current political controversy, I guess. I'm not sure about that.
Okay. So I just wanted to have some fair idea about the fact whether it is being um, understood by public at large. And obviously, you're right. People don't know because the media is not showing, and therefore it is not coming to our light. And Trump administration is very clear on this, that they will not release further, and they have put a uh, full stop on further revelation, further release of the files. So before we'll have 2 minutes discussion on Epstein file, but just try to understand. Earlier, public shaming used to work on the political class, and it has had a lot of, and not because of the legal procedures, simply because public reacted and demanded accountability, um, leading to the resignation of several uh, heavyweight political leaders. For example, Watergate scandal happened in 1972, and which led to Richard Nixon's 1974 resignation. It was a corruption expose and driven by media scrutiny entirely. So think about, not you have a system complementing the formal legal system where some public corruption issue is tackled by public scrutiny itself, not even requiring a formal legal process to be launched. And we have this very famous very notorious rather, Clinton-Lewinsky affair of 1998. And it saw Clinton being impeached for lying about his relationship, and he was totally shamed by public. There was no social media back then. He did survive, but the most important aspect was that he tendered publicly recorded apology, and he admitted to inappropriate relationship with the White House intern, that is Monica Lewinsky, which he was accused of having inappropriate affair, and which was regarded very inappropriate because he was the POTUS, that is the President of the United States, and he was expected to uphold integrity of his office. He apologized, and he did that in a televised statement in August 1998. He admitted to having inappropriate relationship with Lewinsky. And similarly, public shame used to work in the in the British establishment. And Tony Blair, who used to be the Prime Minister of United Kingdom for 2 terms, he was the Prime Minister, and he was the one who built up a case full of lies against Iraq's WMD, weapons of mass destruction. You can still Google it, search. There are YouTube videos where he is seen speaking, building up his case against Saddam Hussein, which was a total lie. Iraq didn't have the WMDs, and therefore media was free. People demanded accountability for the blatant public lies he made inside the parliament. And finally, it turned out that in 2016, he tendered apology for exaggerating Iraq's WMDs, which led to the killings of people. So there was this commission also appointed. So somehow public shaming did work, and he was forced to tender apology, similar to what Bill Clinton did in the Clinton-Lewinsky affair. And we have other examples. There are hundreds of them, but I picked up another example from Germany where we have read about it. In Germany, the two ministers and top-ranking ministers in Germany in 2011 and 2013 resigned for plagiarism, for dissertation plagiarism, and you have a full page on Wikipedia regarding what they did. And India also, coming back to some examples where public shame used to work. We had examples of ministerial resignations since India became independent. Public used to force ministers to resign. And Lal Bahadur Shastri stands tall in that, and he resigned as railway minister in 1956 after a train accident. He accepted moral responsibility. So public shame used to work, used to goad the erring ministers to tender apology or to acknowledge his mistakes or even to resign. Right now, none existing. VP Singh, similarly, he quit as defense minister in 1987 over the Bofors scandal, and after that only he joined another party, Janata Dal, and he was shamed by corruption allegations, and therefore he resigned from the then ministry of Rajiv Gandhi. Natwar Singh similarly also resigned as External Affairs Minister in 2005 amid the UN oil for food scam allegations. So these all resignations were triggered by public and media outcry, pressure, and this reinforced accountability when we contrast it with today's diminished shame. Even a decade and a half ago, in India also, ministers used to resign. Post Mumbai bomb attacks, Shivraj Patil took moral responsibility and he resigned. And very interestingly, he was only accused of changing his clothes. Mumbai bomb attack was going on, and he was seen changing clothes in that very problematic time. He was seen changing clothes on a given day, 2 times. A. Raja also resigned for. So we have examples: Ashwini Kumar, Dayanidhi Maran. So they all used to, and mind it, these resignations happened, accountability fixed because of the public shame they were involved in. Activities of these leaders were not seen ethically right, and therefore public pressure built up and they were made to resign. So in India, we don't see resignation on moral grounds almost disappearing, and it is no longer finding place or mention in our media. And similarly, so much so when we contrast Lewinsky, Bill Clinton's affair, or this German ministers resigning, or Nixon, this Watergate scandal in USA, they all happened without any formal legal processes. And here we have in 2025, Trump is sitting on Epstein files, and because he's himself involved. Let me just tell you what he's accused of. Epstein files, there's a total absence of shame. There is this guy called Jeffrey Epstein, who was a billionaire financer, and he was convicted of child sex offense, and his crime includes being a pedophile. He was involved in trafficking hundreds of girls and supplying these girls to political leaders, from whom he wanted favors, uh, corporate favors he wanted, and therefore he trafficked girls, and then supplied. And it includes, the revelation does not, till now, revelation does not say anything about Trump being one of the beneficiaries, but media, there are YouTube videos emerging now which show Trump in mega parties thrown by Epstein in
Yeah,
his.
Dr. Ashish, sorry to interrupt. Can you just take 5 minutes to bind up, and then we will have an interaction, from the
Okay.
audience.
So just in 2 minutes, I will wind up. So this Epstein file is a damning revelation. It includes names of Trump, Clinton, Ehud Barak, who is a former Prime Minister of Israel, Al Gore, who used to be former U.S. Vice President. Interestingly, the file also names a CEO, Jess Estali, who was a former Barclays CEO. He resigned over Epstein file. So we have also example where public shame did work on the corporate. So we can just in 1 minute wind up. These are the brainstorming points or the reasons as to what is leading to decline public shame, why it is being eroded. So it is precisely because of the social media anonymity. Society is being hugely polarized. The golden days of individualism, media being allowed to use all sensational materials, engaging in sensationalism, and there has been a marked decline of public intellectuals engaging in public discussions. So public intellectuals like university professors or even recognized intellectuals from various academic fields, they are not engaging in public discussion anymore for fear of for various reasons, in particular the suppression which has had on the intellectual suppression which is being reported in several countries. So those are the reasons. Desensitization, constant exposure to scandals. So if you have number of scandals emerging, so it can desensitize the masses, and public outrage becomes very few. Now, some brainstorming points, because I was thinking about what could be the remedial points in this connection. So neutral fact-checking body needs to be, in particular, this is being talked about by the leading author, which I of this of this book on public shaming. So she has talked about neutral fact-checking body, which has a legal position. And very interestingly, somebody has talked about public registry of lies. Mandatory press conference, it comes from me because it's something which can help reduce the incident of lies, and through mandatory press conference, accountability could be fixed. Media panels with intellectuals. Media needs to be told very clearly that intellectuals, publicly recognized intellectuals, need to be made part of the public discussion. Citizen accountability platforms, ethical leadership training, and university fact-checking. This I have thought about. University fact-checking team. University needs to be involved because the university is the center for knowledge dissemination. They are more in touch with the knowledge system, so they are better suited to bring about clarities on any on any lies peddled by the political leaders. So, therefore, this is the final concluding point. In a constitutional democracy, shame serves as a vital social sanction, deterring acts like corruption or abuse that erode the rule of law by aligning individual conduct with the formal moral foundations of governance.
Yeah,
So, with this,
thank you. Thank you, Dr. Assis, for your thought-provoking talk. Already we have several questions and comments here. So I will take first by Mr. Asutosh Thapar. He asks, just a minute, how far can public shame be held sacred in the
can you
world of social? Yeah, the question he asks that how far can public shame be held sacred um, in the world of social media, where any anonymous user can write or abuse anyone without any consequences. Moreover, media trials run unfiltered many a times, which leads to permanently damaging the reputation of a person.
um, this is the area where a lot of work needs to be done, no doubt. An anonymous user misusing the platform, obviously this is the task and the responsibility of the media, the social media platform or the media platform, to ensure that their platform is not being misused. Currently we don't see, because in America in particular they are often protected by the very strong climate of free speech protections. So uh, that's debatable, but somewhere lines need to be drawn. What I what I would, at the moment, what I would like to say that these media platforms need to be made responsible, and some other efforts. As I said, how many times we see these days public intellectuals uh, becoming panelists. Someday we may see, but uh, because they don't sensationalize. Media thrives on sensationalism, and we need to stop it. We need to sensitize the masses that sensationalism. Some tools, like in India, we have this RTP, this National Broadcasting Association, which sometimes do impose penalties on erring reporters and erring media houses. But we need to ensure that their platforms are not misused, and that can only be done through ensuring that there are provisions. There are provisions. One essential argument which could be made in this connection is to see a typical clause called publicly naming and shaming clause, which some commentators have said that we need to provide publicly naming and shaming clause in the media laws, or also in media platforms, social media platforms in particular, so that those who are the repeat offenders could be publicly uh, listed as the repeat violator, and so that public can know and his credibility can come down, and therefore it can deter him from being engaged, and also others could be deterred from engaging in abusive conversation using this the fact that they are anonymous in the and there are pseudonyms which are being used. Pseudonyms, we know that your name is your name XYZ, but you are using on altogether different name, or very ridiculous name, in order to hide your real identity. So pseudonyms could be changed in this connection, or I mean the media platforms could be asked to diverse the names if pseudonyms are being misused. And these days we all see on social media platforms nobody is using their real names while they are engaged in abusive conversations. So that could be one of the ways. But this area, as I said, is still emerging, and people need to debate and discussion. There is needed to ignite a debate surrounding this issue.
Yeah, I will take two, three questions together. One is by Mr. Gopinath. He asked, it is very difficult to prove with factual evidence And Mr. Sudipto Upadhyay, he asked that why are judges being excluded from the realm of public shame, as common people shaming or criticizing them end up facing contempt of court. So
Yeah.
these two issues, yeah.
Uh, for judiciary, there are many other tools because it is far more protected body in the constitutional setup, and it needs to be far more constitutionally protected because their actions could not be politicized. But obviously, lines must be drawn. I will concur with this view that they also needed to be made accountable, but accountability could be fixed by other means. So, for example, we all know that judges operate, must conduct themselves using the ethics or judicial ethics, which they must follow. And we have in India a Bangalore principle of judicial ethics. We may not be knowing, but there is this 1990s Bangalore judicial ethics, which all judges are supposed to follow. And this is an international unofficial instrument. So say they are not engaged. So if you find a judge having a social media platform and using that platform to reply, or they have made statements which are violative of the judicial ethics, so in order to handle those situations of errant judicial behaviors or misconduct, judicial misconduct, we have procedures to follow uh, by means of petitioning the CJI. Like in some states in United States, they have allowed the public to, because in one interesting example, what happened, the judge was having the social media account, and he was found to be a friend of a public prosecutor in that state, and he was interacting with his friend who was who was a public prosecutor there. So the petitioner, who was one of the who was a plaintiff in his court, raised this before the Judicial Ethics Committee. So we need system. So there it brought into the light, public domain, that judiciary or judges must not interact in this way, because it sends out very it can have chilling impact on plaintiffs or those who are seeking justice. So suppose I have brought a case against XYZ, and and that XYZ is being defended by a public prosecutor who is seen to be a friend on the social media platform, or that justice is done almost. Uh, Whatever the outcome will, even if that is fair, nobody will believe that. So we have Judicial Ethics Committee there. So there we don't have this in India. So we need to ignite a discussion surrounding this, um, ensuring that we do have also Judicial Ethics Committee, where the aggrieved could petition against the judge. Other formal procedures already exist in our constitution, good or bad. That is for another discussion. But we need to ensure that judges are also held accountable for whatever they do, speak. If those are not, if those are violative of the Bangalore principles or errant judicial misconducts, then they needed to be held accountable.
Yeah, I will take two comments by Mr. Rajan. Um, he says that see Rahul Gandhi on a broader canvas,
Mm.
even see the Congress party. Rahul is rapidly anti-national and anti-Hindu. This
Mm.
chap and the party are being shamed publicly, but they remain steadfastly unabased. In current times, news of a scandal get buried under the information deluge. Remember Abhishek Manu Singhvi? He was caught on the video in a
Mm.
compromising position. Nothing happened. Indians have too much tolerance and allegiance. I am afraid public shaming will not work here. Only the
No,
rifles will.
but I think that's missing the point, and those are very extreme views. missing the spina sniper. I mean, we have uh, uh, to think about how to improve the system, and we need to be fair-minded in our approach, not politically aligned as such. All political class are much the same, be it in any country. So, what needs to be done in this context is to have more discussions, fair discussions, without any political leanings. Uh, uh, in many countries are facing this situation because of the deluge of social media platforms with little accountability. Public shame is an important tool to regulate the conduct of the political leaders, corporate leaders, and public in general. So we need to see how far the remedies available can deter the misconducts of these individuals who are caught lying, publicly lying, and without having any remorse, without having any shame. So sniper justice is not the solution. That can be lead to violence, internal strife, as we have seen that in Syrian crisis, and in some many other countries where these revolutions took place because of the deluge of social media. The social media platforms, and there is this very interesting dimension to all discussion. How many times we think about uh, these big tech companies sitting in San Francisco, United States, and reaping heavy dividends, revenues out of this, out of these social media platforms, which are now being converted into hate platforms. Hate has become a big economic incentivizer for these big tech companies. Do we know that China has not allowed these big tech companies in their jurisdiction because they knew that these are the calculated designs of the big tech authoritarians. Now, a new term is being coined: big tech authoritarians. So, before countries like us start using social media platforms at a very very high scale, uh, discussions should have preceded as to what it would lead to. Now we have a situation where using pseudonyms, anonymous names, anybody can debase the public discourse. So public discussion has gone down, no denying the fact. The level of conversation has gone down, and it needs to be tackled fast. Otherwise, it will become uncontrollable. So,
Yeah, I think due to lack of time, I will just take these couple of questions together. So there is one question regarding from Srikant. What about the lie being perpetrated to insult people from doing right things? Then another question is regarding the Nathan Herald case, the issue of criminal conspiracy and misappropriation involved into that. Then Priyanka asked, to what extent does the normalization of unethical behavior in public life contribute to the weakening of legal accountability in a democracy? And one more comment is, until judiciary is clean and the third-rate Westminster model is disbanded and replaced by a form of government where executive and legislation are totally separated, India will remain a thick-skinned and a waste model, totally impervious to public shame, barring very rare exceptions.
okay, so are these comments or?
Yeah, I think previous two questions were there. Now this is all, the last one. It looks like a comment. Yeah.
Okay, so as I said, I will reiterate. Um, we have to bring distinction between what we are discussing under this broad public shaming domain, or publicly naming and shaming strategy, with the formal legal processes. We are not talking about the formal legal processes that can take its own way. Law will take its own course. What we are discussing here is the accountability of the political class, accountability of the corporates, of the social media platforms, of the media houses. They because their platforms are being misused. Conversation level has gone down. Public discourse needs civilized dialogue. This so law needs to be also enforced. For example, if we have example of some reporters or journalists being also booked for their for violating media ethics. Uh, but that is a typical course, legal course. What I am discussing here is the role of diminished public shame, which we are not talking about. And in that, I cited the example of the Epstein file. Had it been 1995 or 98, when there was no deluge of media or no social media, even without that, the leader of a country, POTUS, President of the United States, was held accountable without any formal legal processes. So, as I said, HLA Hart or leading thinker says that, or even in our country, Ambedkar said or Mahatma Gandhi said that it exists, public shaming strategy exists as a supplementary mechanism, complementing the formal legal processes. And it is much more required because of the in India we see resignations have stopped. Nobody is bothered even to ask for resignations from the political class. Forget about political divide. The country is far more superior feeling, or country's interest needs to be placed over and above the political interests or the party's interests. So don't get trapped into this political divide narratives, this party or that party. You have to think how to improve the mechanisms and to hold people to account. And we need, and in that discussion, what is very important is to remain critical thinker, critically analyzing, because it helps the country. While you critically analyze, it helps the country system. It points out the problems, and the ones who are accountable or who are in power are forced to bring in changes, and which have stopped because of the fact there is this total absence of impact of public shame, and people, leaders, corporates are little worried or little interested in responding to these allegations of scandals or corruption. This is, and as I said, this is absolutely vital that the formal mechanisms need to remain supplemented, or need to be supplemented with the informal mechanisms which I have talked about today. So in that context matters a lot. The context needs to be understood properly in this regard.
Yeah, thank you, Dr. Assis. On behalf of NRS, National Reconstruction Society, I would like to thank you for your thought-provoking talk. And this definitely is going to generate more and more issues. Already we have more and more questions, but due to the paucity of time, we cannot, so we'll have to bind it up here. And thanks to everyone. Thanks, Dr. Assis, once again.
Okay, Ayush, you can just collect those questions and send it to me on my email. I will try to answer
Yeah.
through email.
Okay, okay.
So thank you, National Reconstruction Society, for affording me this opportunity, and thank you, Ayush, and sir, you also for this opportunity to interact with this organization, and to the audience, and for some very thought-provoking questions which were raised today. So this area is new and needs to be further explored. A lot of brainstorming is needed, and this area is very vital to tackle upfront, because of its severe consequences, because it can have severe consequences on our society. So with that, I would like to end this session, and thank you again.
Thanks to you. Thanks.
Thank you.